Welcome to Fortifying Futures, the podcast that unlocks the secrets of securing your legacy. Each episode is meticulously crafted to demystify the complex realm of estate planning, asset protection, and how your investments are protected. With the expertise of industry veterans and the personal stories of those who have navigated these waters successfully, Fortifying Futures offers more than just information. It provides a blueprint for action. Tune in to Fortifying Futures and transform your legal and financial journey into a strategic masterpiece. Hi, everybody. This is Brian Hill, and we're starting episode 5 of our podcast, Fortifying Futures. And today I have with me Patrick Lane, who is a partner and attorney at Ball Morse Lowe. And Patrick brings a unique take, unique skill set to the table, and that his job is to clean up the messes. Half of his job is to clean up the messes that other estate planning attorneys make, and then even help clients prevent some of those messes, especially when it comes to their businesses. So Patrick, I appreciate you being here. Thank you for taking time out of your schedule to do this. And you and I were talking earlier, and I know that you do a lot of litigation and a lot of cleaning up the messes. What's some of the biggest examples of some of the biggest problems or biggest complaints that you hear from clients when it comes to trusts?
The number one complaint and the number one reason that people reach out to my group is because there's just a total lack of communication from the trustee. So the most common call we get is a beneficiary who knows that there's a trust and it was told that they were supposed to be getting something from the trust, but then whoever's in charge, whoever's the trustee of that trust, is either non-communicative or refusing to give them even a copy of the trust agreement. And so they feel helpless, they don't know what to do, and so that's when they call us and seek our advice on how to just get information half the time, because the lack of communication tends to breed suspicion, and there's got to be a reason that they're not talking to me, and a lot of the time that's true, but sometimes it's not. It's just the trustee is too busy or mad or whatever, and is not technically doing anything wrong, but their refusal to communicate with the beneficiary, which they're obligated to do, then leads to legal issues for them.
So that makes total sense. He's got a trustee that's withholding information, either voluntarily or intentionally, or they just don't know they're supposed to communicate it. What's the next step? How do you get that trustee moving? How do you get them off high center so they are sharing that information?
Typically what we do is we send a demand letter, and we ask for not only a copy of the trust agreement, but for any documents related to the finances of the trust, the assets of the trust. We ask for bank statements. Depending on what kind of trust, we might ask for tax returns. And so that demand letter is kind of the initial step that puts the trustee on notice that counsel's been retained and that they need to get into action.
How when you send that letter and you're just from the hip, how often does that get the logjam flowing and people are doing what they're supposed to, versus how many of they just dig their heels in and say no?
It depends on the trustee. Corporate trustees will, to the extent they have been slow in giving documents, will then usually quickly get into gear.
Right.
Individual trustees, it varies. I would say we probably get as many ignoring it as we do responses, and I've had that lack of communication even after the demand letter be the trustee went to an attorney and it's the attorney's fault that I'm not hearing anything back, or the trustee is my client's brother and they're still mad at him, so
right.
Forget them.
Earlier we used a phrase on one of the earlier podcasts, fiduciary duty. How many of those trustees, those individual trustees, do you think they know what they've been asked to do, or the gravity of that word fiduciary? Do you think they understand what they've been tasked with? For
the individuals, unless there has been trusts in their family previously, almost universally don't really comprehend the weight that office of trustee brings with it.
Right. Yeah, in my experience, I know a lot of people say, well, I'm trustee, so I get to decide what happens with the money or with the family farm. And we have to remind them that's not what it means.
Right.
They still have to follow the rules on that.
Yeah, it's shocking how many of the individual trustees have never even read the trust agreement to know
Really?
what they're supposed to do in the first place.
Really. Now, a lot of those trust agreements, I mean, I draft a lot of those, and there's a lot of legalese inside there that we don't always need. So, but you're saying, surprisingly, that their trustees don't even read it or break it open.
Yeah, or they'll read selected provisions, and then if they don't feel like they need to give a report or an account of what they've done, just either read it and don't care, or don't look at that part of their trust provision that says they do have to give a report to beneficiaries.
Right. So. Well, I've heard it said many times in this part of the profession that people are messy, and so when you try to get people to do what they're supposed to do, it's not always a clean-cut thing. So that's hard. I have another question. When we're talking about trust administration, somebody's taken the time to draft a trust. They've named a trustee, maybe it's a child or a spouse or even a corporate beneficiary, and they're not doing what they're supposed to do. And so you step in and you get things moving. If they don't do what they're supposed to do, if you do send the demand letter and it's not moving, what's next? And ultimately, what's the big stick to hold the trustee accountable for not doing their job? And who has the authority to wield that stick?
That, I mean, as we all say, depends, right, on the trust. But traditionally, in our cases, if there's not a provision for a trust protector or somebody who has kind of built-in oversight over the trustee who can do things without a court order, we have to go to the courthouse and file a petition. And like I said, and most of the time, that initial petition is just seeking information, documents, and accounting. However, inevitably, those same trustees who were being silent or refusing to give information were doing so for a reason. And so then a lot of the times, once we get the documentation and the bank statements and everything, we find trustees taking cash for themselves out of the trust account. And
is that wrong? Is that bad?
I've been told it is.
Yeah.
I've been told it is. And so we have to then file a kind of subsequent action to remove the trustee. And then depending on whether that trustee is the only named trustee or if there are other named trustees, either we get somebody else who was named in the trust appointed, or oftentimes those people will not want to get into the middle of a lawsuit. So a third party has to be appointed, which is another expense, another burden on the trust itself, because the trust has to pay for that person to do what the original trustee should have done and administer it properly. And, short of that, on smaller trusts, we'll sometimes see judges enter an order that the trustee can't do anything with any trust property without a court order. And so that's kind of a cheaper alternative to having a third party appointed.
Right. So if you're advising the next person who's drafting their trust, what would you tell them is important when they're selecting the trustee? If you're going through your criteria, I know when I think of my kids, there's a couple of them that would be great as trustees, and there's one that wouldn't be just because of their personality. So what kind of criteria or advice would you give to somebody who's trying to draft their trust and appoint a trustee?
I think, the who should be named is something that is a case-by-case basis. So
it's not always the oldest, right?
No, definitely not. But I think the advice I would give would be more towards making sure that the trust agreements are distributed so that everybody knows their rights ahead of time.
Oh, like in advance, everybody gets a copy?
I think so. I think that's wise, so that, because then if the person that you've named that you thought was going to take care of things isn't doing what they're supposed to do, at least your beneficiaries who you have named, who you want to take care of out of this trust, know their rights, know what the trustee should be doing, and then can, I think, more quickly take advantage of whatever mechanics there are, whether in a courtroom or a demand letter or things like that. It just, because what I often see is, hey, we asked for this and nothing happened for months, and we asked for this and nothing happened for months, and they wait a long time before they call me. in part because they don't know what their rights are, or even what they're supposed to get a lot of the times. And I think there would be some wisdom in putting deadlines on the trustee when the drafting part of that, a demand by a beneficiary has to be answered within so many days.
Right.
Because, even a duty to report the status of the trust by the trustee upon request, most of the ones that I see don't have a by when. And so then that leaves the door open for the trustee to continue the
charade or the game.
Right,
yeah.
the campaign of non-communication.
Yeah.
So.
No, I think that's true, and I think as I'm drafting trusts, I think there's only been a handful. Well, I've put that in there, so I think that's wise, is communication needs to be done here, and this is how this is done. And as the grantor who's drafting that, they love their beneficiaries, so they want them to receive this, and when they're intentional about it, they're removing the guesswork. So I think that's great.
And if they don't, because there are circumstances where you'll have a client who wants to give something to somebody but doesn't want that person to know the full scope of their assets, or then provide that as well. You know, that this beneficiary is entitled to this section of the trust, and if she demands more than that, or he, then don't give it to him. And then the trustee is acting within their obligations and honoring what the grantor wanted, and I'm not allowed to give you that under the terms of the trust. And that way it gives some protection to the trustee when they are trying to sincerely fulfill their duties.
Follow the instructions. Right. Okay, so let me switch it on you a little bit. We've been talking about if somebody's upset. Can you tell me about a time when the trustee has come to you saying, hey, I've got the trust in front of me and I need help administering this, I need help navigating this because I think someone's pretty mad at me or going to get mad at me, or I can't do what I'm supposed to do?
Sure, yeah, and that does happen usually with black sheep type members of the family who think they're entitled to more than they are, or have fallen on hard times, whatever the reason may be. But even in those circumstances, giving them a copy of the trust agreement mitigates a lot of the issues that could be raised by that person. And the open communication, again, gets out ahead of adding fuel to the fire that beneficiary already has. And so in my experience, getting that person as much information as you can, and you can't control what somebody's going to do, obviously.
Right.
If that's a lot of the reason that I have a job. So but the best thing that the trustee can do is then come to us and say, okay, they're making all sorts of demands, or sometimes we've had them where they live in a trust-owned property and they're just destroying it, and the trustee doesn't know what to do, and so then our group can file an eviction if we need to, and then in continuing.
So you can represent the trustee in that trustee's capacity to help them navigate that.
Right.
Okay. Yeah, I think that's something when I help people administer trust, I think they don't know what they're supposed to do. And in fact, in that circumstance that you brought up, they have a duty to the other beneficiaries, not just that one living in the house, but the other one to protect that asset.
Right.
So they have an active duty to go out and try to clean those messes up or stop them from happening.
Right. And a lot of those, the longer you wait, the worse it gets. Right. And then, oftentimes we see trusts that don't have any cash or minimal cash, and the main asset is that property. Then you don't have the cash to make the repairs, and then you just have to be stuck with the loss of value caused by the damage to the property when you sell it, and that leaves everybody in a worse
it's just
position.
a downward spiral, right? It keeps getting out of hand. So what we've talked about a little bit is kind of a reactive stance, right? We drafted a trust and it didn't go well, and the trustee's not doing their job, or when the trustee needs help to do their job, they can come to you. But I also know that you're involved time to time with business planning and business succession. Can you tell me about a time when you've helped somebody navigate, maybe they've got a business, maybe it's over the taxable estate or taxable limit exemption amount, and maybe it's not, but tell me about a time when you've helped create a business succession plan in regards to estate planning.
Sure, yeah. We've got a lot of clients who come and they own their business. It's a successful business. They get into a later stage of life, and they're kind of wanting to make sure that the business is taken care of the way that they want it to be. And so the most common situation where we bring in a trust in that scenario is they've got the LLC created, and then they have this estate planning. They're getting ready to take a big trip or something. So
Right.
that is most often when we get those calls. It seems like so. That's when we usually say that they need to create the trust, and then we transfer the ownership of the company into the trust.
Wait, so at that point, the trust owns the LLC.
Right.
Okay.
And so within the trust, because typically the operating agreements don't have Bobby Sue gets this, Mark gets this once the actual owner dies. And so that sort of what happens after death needs to be taken care of it within the trust. And that way the trustee can distribute the ownership however our client wants it.
Right.
Because those types of provisions are not proper for an operating agreement. The operating agreement is supposed to be about the business of the business, not what happens to the owner with the owner's shares. So
Right.
that's where the trust comes in, and then the asset protection piece of that's very different, and where you put your assets and what kind of entity and how you structure that's a much bigger conversation.
Right, and that's much more complicated from that standpoint. But I think you bring up a good point. We talk about assets, we think of dirt and real estate and stocks and bonds, but a lot of times the companies can be the biggest asset, but it is owned by the individual, either one spouse or both spouses at some level. And if they were to die and they were the sole owners of that company, then we've got a problem. Then we have to probate it, right? So if we can set it up in a way that the trust owns the company, the trust can avoid probate and take care of distributing maybe not the day-to-day operations of the company. It's still going to go on as it is, but the ownership will be dictated by the trust.
Yeah, and there are some technical, not technical, but statutory laws that have some pretty drastic consequences for when an owner dies, or needing the need to get a probate filed very quickly to carry on the business is something that a lot of people don't think about after mom or dad dies. But there are rules and laws that say it needs to be done, and it needs to be done quickly, or else this company doesn't exist anymore. And so that's something that I've seen recently that it's just something people don't think about. But it's provided for under Oklahoma law that this company might be non-existent anymore if we don't do something within a probate, whereas if you got it in the trust, you don't have to worry about that.
Right. Yet another good reason to do an estate plan,
Right.
to do a trust instead of leaving it up for probate.
Right.
And so whether it's a will or non-will, if you don't have a will, both of those have to go through probate. So we want to avoid that.
Right.
Speaking of probate, I know sometimes you get to do litigation and result around probate. Tell me where that litigation typically comes from. And again, a probate is somebody that has a will or doesn't have a will, and they've passed away, and we've got ownership and title issues because they haven't put it in a trust. So tell me where the litigation comes from for probate.
There are different pieces of probate that are heavily litigated, at least in our experience. In the case where there's not a will, who gets to be PR and gets to administer the estate is often a hotly contested matter, and where a lot of litigation lies. But even, if there is a will and it names somebody, there are still fights about who gets to serve if, for instance, the person named has stolen money while mom was dead or while mom was alive. And so just because they're named in the will doesn't automatically mean there's not a fight on it in the right circumstances. But once that person is named executor, if they're not doing their job, and the most common one that we see is not filing an inventory and not giving an inventory of what the assets of the decedent were when they passed away. What did mom own when she died? You're supposed to do that relatively quickly under Oklahoma's laws. So oftentimes, though, it gets ignored. So
yet again, sharing information, disclosing it, so all the heirs or whatever, whether it's for a trust or a probate, they have all the information. It's hiding the information that seems to be the common thread here.
Right. And I think kind of the last one is the the legitimacy of the will. That can be a hotly contested issue, where which ranges from, is that really her signature, to did she know what she was doing when she signed it? Did she have her mental faculties when she signed the will? And so there's a lot of avenues of attack on wills, though candidly it's often a very hard case to prove that the will is invalid. But it certainly does happen routinely.
Right. I know when we draft wills, we follow the Oklahoma statutes where attestation clauses and witnesses, and it's a very formal process, what helps us avoid those challenges in the future, because greed is a real thing and people show up and sometimes they crawl out of the woodwork when money's involved. So we want to do everything we can to protect our clients.
It is continually shocking to me how different people become once their parents pass away and money is up for grabs.
Right. It happens.
That I think, although, is another reason to get the trust, because that, where I have seen that most often, is within a probate, where either somebody had access to mom's accounts before she died and they took money, or after she died they became PR and they spent the money and didn't account for it. And so much of that could have been avoided had there been a trust set up and been a proper trustee. And obviously it can't be avoided completely because we routinely file trust litigation lawsuits, but the probate aspect of it can be. I mean, it's a different fight. It's a different courtroom. There's a lot of overlap, but the rules are different in a probate versus in a civil suit when you're doing contested probate fights as opposed to trust litigation.
Right. And I think it comes down to when people are talking about doing estate planning or business succession, which you can help them with, whether it's making sure their kids are taken care of or who's going to be in charge of that. It's being intentional with their plan. It's being thoughtful about it instead of maybe a shortcut. I mean, I've seen some people try shortcuts where they put their child as a signer, one signer on their bank account, and the other kids aren't signers on their bank accounts. We've seen lawsuits from that. And I know that when people try to save money when it comes to estate planning, when people try to save money when it comes to business succession, ultimately it costs them more in the long run, possibly, because it gets more expensive to clean up that mess.
Absolutely, always. I mean, in my experience at least, the money that had to be spent because things weren't done properly at the outset was significantly more than the cost of setting things up properly. And you mentioned shortcuts. I think I would caution everyone who is considering putting somebody on their bank accounts as a signer or an owner to make sure they fully understand the consequences of the different ways you can set up bank accounts to transfer after you go. First, there's the payable on death, there's joint ownership, and there's the signer that you're talking about, which can't prohibit people taking money while she's still with us, but at least kind of locks down once mom dies, or dad. I feel like I've said mom a lot. I don't know why.
That's right. It happens. Both of them will pass, right?
Right. So that one to me is the one that I think gets most overlooked and just signed without some real consideration on the what it means if we're joint owners and what the consequences are for that, because that's different than if they were just a signer, and the payable on death designations are different than the joint ownership, and there are some very real legal consequences for joint ownership that make it difficult for other kids to enjoy what they should have enjoyed, which is mom wanting or dad wanting their assets to be split between the kids. Joint ownership runs afoul of that.
That's right.
And so I think that one is one I would really recommend people take a hard look at how their accounts are set up if they are taking those shortcuts.
Right. I do too. And those banks have different forms, and those forms mean different things. And maybe they're just a signer where they have access during life, or maybe they are a joint owner and they could spend all the money instantaneously because they own it, or a creditor could latch to it, right? There's a lot of different ways that those decisions have consequences. And I think the takeaway here is that all of this is connected. right? Your checking account and the way it's owned, and your investment account and your assets and your trust and how they're titled, all those things, they're all connected. And I would encourage those people listening to really to slow down and to do it right, because trying to get through this on a short circuit or a shortcut to save a few bucks on this is just not the way to go. It creates a lot of tension. And one of the things that you and I have talked about in the past, but haven't really today, is the emotional side of this. You know, when a child has the legal right to spend all the money because they were payable on death on a checking account, but the other children don't have it, and you brought that up, legally that's okay. But what about the other children? They're going to feel left out. They're going to feel ostracized. And so what are they going to do? Likely they're going to lawyer up maybe and try to go after somebody who legally has the right to that, but emotionally doesn't.
Well, and then that person is spending their inheritance on people like us instead of enjoying it, which is what their parents intended to do. So, or, you know, if they were supposed to divvy it up a certain way, they decide not to after mom and dad died, and that happens routinely. So, and the emotional component is different in these types of cases because it's always family, and it is elevated and amplified, and it can cause people to make decisions that they wouldn't otherwise make. So that is a real component for sure.
Right. So I've got one last question for you. Good or bad, this next scenario? I'm going to give everything to Sally Sue, and she will divide it up because she knows what I want.
Really bad.
Really bad.
Really, really bad.
That's the official answer. So those of you who, sometimes we don't want to do that. We don't want to think about our estate plan. We don't want to think about the business. We don't want to think about all those things. So we just take the ostrich effect, right? And then we ignore how do we do it, or we make it really easy and go down the road, but we're just setting our family up for failure, just like you mentioned.
Yeah. And again, the emotional component, or maybe Sally Sue was a worse person than you thought she was, or maybe Sally Sue is the only person left talking to you at the end of your life. Regardless, if you want your assets to go a certain way, you cannot, as much as we love our family or we love our friends or the people who are supposed to divvy this up, you cannot, in my experience, trust them to do so when you're not there. And I have too many cases that I have currently that are like that support that.
Right. Well, I appreciate that, Patrick. Thanks for taking time out of your day to visit with us, and I appreciate your wisdom and guidance, and appreciate it. Thanks, sir.
Happy to be here. Thanks for having me.
Thank you for listening to Fortifying Futures. This is the podcast that unlocks all the secrets and all the mysteries surrounding estate planning, and we want to make sure that we're answering all your questions. So keep them coming. Let us know what's on your mind. Let us know what concerns you may have or anything that we didn't get to. We'll do our best to get to those on the next podcast. And you can reach out to us via email at clientintake@bml.law. Again, that email address is clientintake@bml.law. And you can always call us at 405-701-5355. Again, that's 405-701-5355, and check out our website at bml.law. There's a lot of great information out there, a lot of great resources and tools, and our goal at Ball Morse Lowe is to provide thoughtful law for today and in the future. Thank you.